heard appeal in the matter of Alame, others, and Shell Plc and another?
Yes, good morning. We left in the March 2024 judgment. I know you were going away to read it overnight, but if I might just take you to a couple of passages within it.
Yes.
So it is in Core Bundle 1, tab 15, and if we can...
You just give me a second while I get the screen sorted. Yeah. Thank you.
And if we could start, please, at paragraph 13, so page 256. So paragraph 13, not possible to make a principled selection of lead cases. Yet this litigation must progress only way is through the all or nothing case, in which the claimants are holding the defendants responsible for all loss arising from oil pollution in the Bille region between 2011 and 2013. And therefore she orders the 3C's trial. And then if you look at 14, and just halfway down, also draw your attention to the scope of the factual trials I presently envisage it will be an examination of all oil contamination in the Bille area over the period 2011 to 2013. And you have our point that we obviously say that is in many ways a bigger undertaking. It's not going to deal with liability, and the aim of it is to get to a point whereby if it's found that the defendants are not responsible for every single piece of contamination, then these claims will fail. That obviously is a grievous error which we ask this court to overturn. Then at 14, she sets out her current driver to the decisions on the various disclosure issues, what she has already said. So in other words, when we come to specific disclosure, and this is important because in relation to specific disclosure, she expressly refused to order that any documents relating to liability were disclosed, which means we are missing a very important part of the picture. And then if we can go forward, I think, then to paragraph 22, which is at page 259. And she says, last three lines, for now, applying well-established principles of English law, I regard the claim as an all or nothing case and approach case management, including disclosure on that basis. So all of the disclosure that she's ordered is through the prism of the global claims all or nothing case. And if you look halfway down, fourth line of paragraph 23, you will see that she also took no account of the information in balance when she was considering whether to order disclosure. She said it wasn't a sufficient reason to order disclosure where relevance has not first been established. And then if we look at paragraph 23...
You wouldn't quarrel with that, would you? It's got to be relevant to be disclosed.
Yes, I agree with that as a general statement. Of course, what she sees as relevant, we say, is skewed, because she sees that the only question is being this all or nothing trial. So she will only order disclosure of anything that she sees as relevant to that question, which is why anything that we wanted that related to liability, which we say will be important to where these spills took place, she refused to grant.
On your understanding, if we take Mr. Igwe, who says that from when he went there in 2000, it always smelt of oil, there was always contamination. But it's got worse and it comes from near the manifold. Just taking him as Is it your understanding of, at any rate, what the defendants would contend for, that if on an individual basis Mr. Igwe would fail because he can't prove causation, the whole case collapses?
Yes. My understanding is if there's one instance of pollution that we can't attribute to the defendants, the whole case goes.
Okay, thank you. Well, if that's not right, Lord Goldsmith will explain it to us.
And just going back to your point, my Lord Males, if we turn over to 260, and you will see at this point Mr. Hermer has always, his starting point has been please order standard disclosure. But you will see halfway down paragraph 23, for example, she says maintenance records are irrelevant. And the reason she says for that is, well, there's strict liability for pollution under Nigerian law. Now, of course, that doesn't take account of all the other claims that I've taken you to, including the negligence claims, or indeed parts of the Nigerian statute based on neglect, for example. So her view of relevance, with the greatest respect to the judge, is completely seen through this prism, that all she has to do is order a trial of all pollution, find that there is one that's not attributed to the defendant, and these claims go. And
it's not accepted, is it, that under, in these general terms, that under Nigerian law there is strict liability for pollution arising from equipment failure? I thought that was one of the Nigerian issues, but maybe it's not.
Yes, I think it's quite nuanced. We've obviously given you the Nigerian statutes, but I think that's well, we'd have to look through them in detail. There are a number of very detailed questions that arise in relation to the correct construction of those statutes.
Yeah. I mean, there's a preliminary issues trial with a vast number of issues of Nigerian law
Yes.
to be determined. So
Yes.
it may become clearer once judgment on that has been given, what the position is. But at the moment, there's quite a lot that's an issue.
Yes.
Difficult to see why maintenance records would be irrelevant anyway.
Yes.
In a claim based on failure to maintain.
Well, correct. And unfortunately, this is why we say there's become absolute tunnel vision. And I'm afraid I'm going to take you to a subsequent hearing where it becomes even clearer, which was the hearing which led to us writing to the Court of Appeal to say, please hear this urgently. We're very, very worried about the approach the judge is taking, because it has now become about this trial. If you can't prove that, that's it.
And I suppose maintenance records, even on a strict liability basis, might say things like, we better go and plug the gap at such and such a location because it's spewing oil all over the place.
Well, absolutely, absolutely. And it may be relevant to the leaks. And I take you to this in some detail because it really illustrates the things that we faced.
One can readily accept that there may be a balance to be struck
Yes,
between your need for information and imposing outrageous demands upon the defendants.
yes.
But that doesn't mean that a global claim is the right vehicle.
No, and indeed, when we come to look at what Leader 4 asked for, my submission will be that all of those documents should actually be very readily available. So we are not asking the defendants to go, for example, and trawl through emails, which obviously will in due course be part of standard disclosure. These are all records relating to these pipelines that if you read the statutes, they should actually have all of these things kept neatly. They're supposed to be submitted to the regulator regularly.
Well, given the nature of this, it's pure speculation, of course, which I couldn't possibly indulge in, but given the nature of this claim, it would be astonishing if the documents weren't in the lawyers' offices already.
Yes.
Now, can we just see where these points about disclosure come
Yes.
in? Because I take it that even if you succeed in persuading us that it shouldn't be a global claim, you're not asking us to make decisions about what disclosure should be given, or are you? But rather identifying these as what you say are illustrations of how the judge has gone wrong as a result of categorising it as a global claim. Is that the point, or is it something else?
Well, I think I am showing you, I'm showing you, yes, how wrong things have gone because of the telescope of global claims, which infects everything that's happening. I'm also showing it to you because it's obviously a matter for the Court of Appeal in terms of what directions you give or feel able to give. You will see the invitation in fact, the defendants agree, they invite you to give case management directions if you are with us on global claims being wrong. So that's in their skeleton. What we have done overnight is to update. There was a draft order prepared for the GLO. That's in Supplementary Bundle 2, tab 34, page 665. We're in the process of just trying to put together what a draft order would look like. Because we say it is very, very important that in parallel with the preliminary issues trial, that standard disclosure takes place as soon as possible, and that's what we ask for. Then we proceed to the lead claims, and we'll go through this later today. But we've set out very clearly what we see as the route to resolution of this.
If you're asking us to give specific directions as distinct from identifying, as it were, a broad way forward, then you better identify at some point exactly what the directions are that
Yes.
you're inviting us to give.
Yes. Yeah. Okay. We can hand these up now if that would be convenient, and give a copy to the other side, because these are the directions that we would propose to be given.
Have you had I know you say you've given them to us. Have you had an opportunity to discuss them?
No, we haven't. And
Would it be more sensible to take
it.
that opportunity
Absolutely.
before handing us something which you can say, at least contingently, either is or is not agreed?
Yes, of course. Assuming the other side are willing to discuss them with us, we'll of course very willing to discuss them with the other side.
I haven't seen them yet.
Yes, and just for the record, you asked me about whether the defendants accept its strict liability. Their position is set out at paragraph 33 of their July 2023 skeleton, which I can give you the note for. Supplemental Bundle 1, tab 11, page 119, and it's paragraph 33. It says it's common ground that 11.5c imposes strict liability subject to the express carve-out in respect of oil spills caused by the claimant's own default or the malicious acts of a third person.
Yes, so it's limited to 11.5c and subject to the carve-out. So it's not a as it were, a general acceptance.
No, and we also dispute that carve-out and the way it's construed.
Yes.
But
Right.
yes.
And it's only strict liability if conditions A to F, paragraph 31, are all fulfilled.
Yeah.
Looking at this document,
Yeah.
there was an oil spill. The SBDC was the license holder of the relevant
Yes. Yes.
pipeline,
Absolutely.
and
Yes.
so on.
Yes. Yes. So then, if we then if we can go back to paragraph 24.
With the judgment.
She says this about disclosure: some of the documents sought may be relevant and proportionately disclosable for other reasons, but not on the sole basis that they might have information which might assist the claimant in identifying which events have caused an individual's loss. That's an incredible statement. She says that's classic phishing. So although we've submitted that we need these documents to prove our case, she says we can't have them. And then she says, I repeat, the claimants have chosen to bring a case based on multiple polluting events of many differing kinds occurring in a wide area over an extended period of time. It's for them to prove the necessary clarity so as to permit disclosure, which is properly tethered to the issues. The defendants are not to be expected to throw open the doors to their archives or to put a general trawl through their records. The tail must not be allowed to wag the dog. But with respect, that means the claimants are an absolute catch-22, and we cannot prove our case. And we're being denied access to justice.
You said yesterday, if this view prevails, that's the end of the case. I think. Did you mean to say that?
I said in the judge's mind it is, but yes, it's obviously the wrong approach. The only hope for us would be, you'll see at various points the judge says that her mind might be changed by something that happens. So as we go through this judgment, you'll see at the end she says but it's all very uncertain. So the way she justifies the position she's taken is we might persuade her differently. The problem is that involves proving what we can't prove. Of course, it is possible something might emerge during the Nigerian law issues, but there is a real question mark about what happens now going forward, because in my submission this is a case that really needs a fresh start, and one can see as one goes through this quite how
It's not necessarily a fresh start, it's a fresh approach.
a fresh approach, yes.
How is there to be an examination of all oil contamination of the Bille area over the period 2011 to 2013, reading from paragraph 13, without the defendants throwing open the doors to their archives?
Well, quite. We're still embroiled, I think, in discussions about what the 3Cs trial will entail, what it will involve, but absolutely. It's to be done on the limited documents that have been ordered, and then, in fact, we believe that what's been provided is even more limited than what was ordered.
Remind me of what the 3Cs were: contamination, causation, and something else.
And consequences. Contamination, causes, and consequences. Okay. Yeah, so contamination, causes of the contamination, and consequences. I mean, in some senses, and we'll see, the judge actually uses the word inquiry at a point in time. So then, could we please move forward to 32, page 262. We have, in my respectful submission, another somewhat confused paragraph, because she says, in circumstances where the factual trial will at present need to focus on all oil polluting events during the period 2011 to 2013, and where there is evidence that the JIV reports are inaccurate, proper disclosure will, in my view, require the defendants to search for documents which are relevant to the subject matter of that trial. This cannot be restricted to documents relating exclusively to spills which have an incident number, but must include material which may point to other incidents. Shell and their representatives will be better aware of what such material may be, but the evidence in Modi 6 suggests that asset monitoring reports may be a place to start. I do not intend to suggest there should be wholesale disclosure of all such reports. But if and insofar as such material does indicate a breach or spillage, whether because of a pigging run has noticed corrosion or breach in a part of a pipeline, or because of the pipeline oil pressure data has noted a reduction at a particular point, I would consider such material to be relevant and disclosable. And then she goes on to consider the various categories of documents at 34. This is where specific disclosure was sought in the alternative, because we were not permitted to have standard disclosure. Reports of significant incidents, she says those are relevant to the factual trial, and then she discusses various items of specific disclosure. I don't propose to go through all of those because we say the premise on which they're based is wrong. What I do want to do is draw your attention to 267. This is where she deals with standard disclosure. And she refers there to a statement from Mr. Renshaw. We don't actually have these paragraphs in the bundle. But the great irony in this case was that actually, until all of this happened, the parties had made very good progress towards agreeing what would be disclosed by way of standard disclosure. So you will see that he dealt with that in his witness statement. He refers to the various discussions which the parties had prior to the July CMC and to the points of agreement which appeared to have been reached at that time. And then she says at the hearing, Mr. Hermer spent relatively little time other than to press the court to make an order requiring standard disclosure to progress side by side with specific disclosure in preparation for the PI trial and the factual trial to follow. And then at 50, we see Mr. Hermer making a reference to the Bodo litigation, where Mr. Justice Aikenhead had made that very order. And he also drew attention to the fact that the parties to these proceedings had made progress towards identifying keywords and persons earlier last year before the November judgment, and he asked that to continue. So it is a great shame that what happened obviously stopped those agreements from being progressed and from the court ruling on anything that remained in issue. Then she recites the defendant's submissions against standard disclosure. And then if we turn over to 269, last 4 lines of paragraph 52, again she comes back. The status quo is that the claim is all or nothing. That being so, the defence would resist an order which would put them to the effort and expense of disclosure exercise. So that's the defendants effectively saying again, this is an all or nothing case. Don't give standard disclosure. And then at 53, she says, I sympathise with the defendants. Whilst the case is at the present stage generalised allegations of breach where particular events are not tied to particular breaches, I do not see how fault-related disclosure can properly and sensibly be pursued. I say that's simply wrong. It could, of course,
she goes on to say, without it ending up as a wide-ranging inquiry of all activity in the region over the pleaded period, which is exactly what she's just ordered.
Correct. It is, with respect, very unsatisfactory. And then you will see at 55, the bottom paragraph, she says, having said all this, I emphasise the court remains adaptable, open to a reconsideration both of disclosure and the future path of this litigation in the light of subsequent events, such as decisions made at the PI trial or any future permitted amendments. I recognise this imports a degree of future uncertainty for the parties in the court, but that's unavoidable in a case of this size and nature. And we say that's completely wrong. That's why you deal with this through lead cases, and why the discussions that the parties were having in relation to standard disclosure, where we'd actually had agreement on lots of issues, should have been allowed to progress. So then we see the order that she made at 14, which my Lord Justice Mayles averted to yesterday, page 241. And you will see that she actually went so far as to make these declarations. that the claimant's claims are to be progressed on the basis they are global claims, i.e. all or nothing claims.
I'm very sorry, I'm obviously in the wrong place. I'm looking at a transcript.
Sorry, it's page 241, tab
Of-
14
Of the supplemental one, of the core.
of the core bundle.
Sorry, my fault.
So that was the declaration that was raised yesterday, and then she said, secondly, the claimant's pleaded case precludes case management of this litigation being organised by reference to the selection of lead claimants. Now, as you will have seen, we say that that's wrong, even if you were to be against us on the global claims point. Because, as we've seen, the 3 C's trial is a far less satisfactory way of dealing with this than having a trial through lead claimants.
Page 241,
Yes.
declarations 1 and 2 are the real focus of your attack on this appeal.
They are.
And what we do, if we are with you on that, is more out in the open. That you're going to give us suggested directions.
Yes. So we will give you suggested directions after consulting with the other side. Obviously, if those could be agreed, that would be very helpful.
It would.
We have also, you will see in the penultimate paragraph of our skeleton for this appeal, the global claims appeal, which I'll take you to, set out very clearly what we propose to do in relation to pleading out the best particulars that we can in relation to the individual claimants, in relation to the lead claimants.
The order goes on to provide for specific disclosure under quite a large number of headings. Has any of that happened?
Sorry, I didn't hear the last bit. I heard that bit, the orders, the specific disclosure, and then I didn't hear.
Yes.
Yes.
Well, the order is for the defendants to provide disclosure on a rolling basis, whatever that means, of about 15 categories of documents between the 29th of March and 31st July. Did that happen?
Well, I will go through what we have. It's very limited, and we believe even what they gave us must be incomplete, and I will go through some specifics on that.
I didn't want particulars. I just wanted to know whether so they have provided disclosure in purported compliance, but you say it's inadequate.
Yes, that's right. But it's missing, for example, anything on liability. You've seen it's not going to have maintenance records. It's missing huge. It's not got any fault-based disclosure at all. So it's missing a huge piece of the puzzle. We're not able to. That's the point of. We're not able to plead out our causation case, or indeed advance these claims more generally, because following the 3 C's trial, there'd have to be another trial if the claim survives on liability.
The order goes on at paragraphs 6 to 10 to give directions for disclosure under the heading of disclosure for the 3 C's trial. If your appeal against the global claim declaration succeeds, do all those paragraphs fall away?
Yes.
Your appellant's notice says that you're asking for the declarations at paragraphs 1 and 2 to be set aside.
Yes.
I understand that, obviously, and you've made some submissions why that should be so. And you say, with the effect that the consequential directions set out in that order will be varied. I must say, I'd understood that they would be varied because the matter would go back to the judge to give directions in the light of whatever we might say. But you're asking us, are you, to give the directions ourselves?
Yes, I am, only because of the particularly unusual history, and I appreciate that it is very unusual to ask the Court of Appeal to do that. It is something that the defendants agreed would be a good idea if you felt able to do it. And certainly if we can make progress towards agreeing those, then the Court may feel more able to do it. But there there is a concern about, and again we will see whether an entirely fresh start would be the best thing for this case. But again, we leave that in the hands of the court.
Okay, I understand what you're asking. Thank you.
Then, so following that judgment, there was then a further CMC, and I'm sure the court gets the point, but actually this is all far more complex and far more difficult than just ordering standard disclosure and lead claimants. Every hearing there's a disagreement about what's been ordered or not ordered. So there was a further CMC on the 11th and 12th of June 2024, and the transcript of that hearing you'll find in Supplementary Bundle 2, and this is the hearing that led to us writing to the Court of Appeal. So Supplementary Bundle 2, tab 21, and if I can take you to page 429, please.
Did I have that letter before giving permission?
You did. I think so, yes.
It rings a bell.
Yeah, I will. Yes, I'll take you to the transcripts and then I'll take you to the note.
The reason why I asked is I gave permission on the 21st of June.
Yes, yes, and the note is at 429, my lord.
429.
429, yes, tab 21 is the note. And that was sent to the court on the 18th of June.
I have a sort of feeling that may be what stirred me into action. When confronted by a significant number of papers.
And if you just look at the note, it's page 430. Obviously, at that point, we had an extant permission to appeal application pending. And then paragraph 2 identified the Global Claims prison. And you will see at 3, you see the judge has indicated she considers the manner in which that test, that's the Global Claims test, is to be applied is in a blanket fashion to every claimant, without reference to the disparate impact the oil spills will have upon different claimants living or fishing in different places. And then you'll see at the bottom there was a quote from that hearing which had given rise to even more concern than when the original application was put in. And then if you turn over to 431, on the judge's analysis, all claims may fall to be dismissed, even if damage to any number of individual claimants is shown to have been caused only by oil contamination for which the defendants are liable. And then 5, this mistaken approach to causation pervades and distorts the judge's approach to case management. This was a hearing, if we look at 432, it wasn't Mr. Hermer who appeared at this CMC, it was Ms. Hoffman. We only have the transcript of it. Obviously not a live recording, but we have extracts, 438. And if I could ask you to look at the bottom box on 438. This was the exchange which gave rise to particular concern, both because what was said was difficult to follow and because of how it concludes. So at line 21, Mrs. Justice May starts, and I'm going to go through this. It's actually cited, this passage, by the defendants in their skeleton for this appeal, for reasons we don't understand. They cite this and say, this shows the judge is dealing with this in the correct way.
Well, you don't have to read it out. We can read it to ourselves.
Yes. Well, perhaps if you could just read it to yourself.
Sorry, just to help me, which page are you on?
Sorry, it's 438, and it starts at line 21. So you see there's a reference to Miss Kaufman's submission, and then we have Mrs. Justice May. I think it's a question of identified. If you could just read that through.
Yes, thanks. So I didn't catch up because I was looking at what was said in the note.
Yes.
At paragraph 5 on page 5431, which seems to make clear what is in the judge's mind, that if there's pollution anywhere for which Shell are not responsible, then all the claims fail.
Yes.
That spells it out. And that is the bit you quote in the note.
It is, but it's set out in full, and it's important to be read in full because it is, with respect to the judge, quite difficult to follow at points.
Discussion seems to become stuck. Do you want us to read to the end?
Sorry. I wasn't sure if you'd read to the end.
I didn't mean your submissions. I meant the discussion of which this is a transcript. Miss Kaufman and the judge seem to say the same things to one another several times.
They do. There are two things I ask you to take from this. One, the state of the judge's mind at this point, and the repetition of the words. We see it at 22. If you don't establish that, you lose.
Yes.
We don't have obviously a recording of how that was said. But I don't think it was said in a particularly pleasant way. It was then repeated. So if you look at 167 lines 5 and 6, if it's impossible to disentangle it, then you lose. And then Ms. Kaufman's obviously saying, please keep an open mind for the Nigerian trial. Line 19, Mrs. Justice A, must I? Why must I? Why shouldn't I go ahead in the way that nobody suggested the global claims view is nobody's produced Nigerian law, evidence to make me think differently at the moment. And then if you go to the very end of this, paragraph, page 441, at the bottom, a global claim starts from the premise that in order to succeed, the claimants must establish that all the contamination causing loss that harmed them came from
What
oil.
are you looking at? Above internal page 178.
Sorry, 441, just above 178, the end of that line says, because a global claim starts from the premise that in order to succeed, the claimants must establish that all the contamination causing loss, harm them, came from of which the defendants were responsible, and to the extent that there is any more than trivial part contributed to by oil, which they are not responsible, the claimants lose. There's no further inquiry about whether it's TPI or operational, this particular part of the loss.
Well, that's clear enough, isn't it?
It is clear, and that's what led to the note from council to this court, and kindly this court looked at it very speedily, and here we are. But I do ask you to bear in mind that the defendants rely on these passages in support of how this claim's been approached. We went through yesterday global claims. I need to deal very, very briefly with two authorities where the defendants have said that global claims is not confined to claims concerning construction contracts. And I just want to look very briefly at Barthélemy and William Clark, and then I want to move on to how we say this case should be dealt with, which is set out in Arch and then set out in an incredibly erudite and helpful piece by Professor Stapleton. So if we can look at Barthélemy is in Authorities Bundle 1, tab 4, please. Page 40.
Thank you.
This was a claim for breach of warranties in an investment agreement. So in other words, this is a breach of contract case. The claim concerned a dispute regarding the construction of a hotel. And we can see that if we turn to page 41, it's a decision of Mr. Justice Waxman. And at paragraph 1, he says the case concerns the development of a hotel on St. Bart's. And then at paragraph 4, you will see the reference there to the claim for breach of warranties in the agreement relating to the adequacy of the specification for the hotel and its budget. So, in one sense, this isn't a construction case per se, but it is about the construction of a hotel. And then at paragraph 125 of this judgment, the judge refers to the Walter Lilly case,
Could you give
page
the page
62.
Page number?
62.
62, paragraph 125. And he talks about global claims, and he says there's a resemblance to the primary claim of BH here, attributing the entirety of the increased cost of construction of the hotel to breaches of the specification and or budget warranties. The context, of course, is very different, but the resemblance remains. And then if you turn over the page to 63 at 127, you will see the passage that is quoted out of context by the defendants when he says that the global claims rule is not a special rule of law applicable to construction contracts or indeed any contract. It's simply an application of the general principle of causation loss relevant to the context where global claims were made.
Can I just read what Mr. Justice Aikenhead said in
Yes.
Lilly as quoted?
Yes.
Some people in court may know this passage by heart, but I don't.
you rely on E. You rely on little e, the last bit.
Well, if we're in global claims territory at all, so we
If
would
you
rely
were
on
in
that.
global claims
If we were, we would say that actually the test has been misapplied in this context. Absolutely, and that was the whole point of Walter Lilly. In Scotland, the global claims doctrine had already been ameliorated, and in Walter Lilly, Mr. Justice Aikenhead obviously made clear that that also applied in England. But that has nothing to do with this case, and we'll come on to see why. And when Mr. Justice Waxman applies it by analogy, one can see the analogy very clearly. He also himself says it's not restricted to any contract. He doesn't purport to be giving or setting out any test in relation to environmental claims, tort, any of those issues which have been dealt with at length in other authorities. And just a couple of other points that I did mention yesterday, but just to re-emphasise them. We can see this passage from Mr. Justice Aikenhead is extremely clear in terms of explaining why this principle exists, and in particular at D. There's nothing wrong with this kind of claim per se, but obviously you have to prove on the balance of probabilities that the loss you've incurred, namely the difference between what it's cost the contractor and what it's been paid, would not have been incurred in any event. And it is within this context that this has also been elevated from a substantive principle to a point of pleading. What Walter Lilly has helped with in the construction context is now we see far fewer claims actually being stopped at a pleading stage. I can't think of a single case since Walter Lilly where we've had summary judgment or a claim being struck out. Whereas before Walter Lilly, we used to have a situation where people would routinely apply to an arbitrator normally because final account claims tend to be dealt with in adjudication or arbitration, or to court, and say this claim should be struck out. In fact, post-Walter Lilly, I can't think of a case that's actually been struck out on that basis, or not allowed to proceed in the way that
you can't think of a case where this analysis has been applied by the claimants, but the defendants have successfully struck out.
Correct.
Yeah, I understand.
Correct. Because Aikenhead's approach is also very pragmatic. So you can slice out something even if you can't precisely quantify it. But again, it is a completely different context. It's a contractual context. It's a contractor who knows as he's going along the job is costing him more money. He knows at the end that there will be contractual provisions that he will want to claim under, extension of time provisions and specific contractual provisions for more money. And all the court is saying really is, if you don't keep the right records and you can't prove your claim, that's your own fault. Because as you're going along, you could do that. That is nothing to do with what happens here, where somebody suffers a tort. And again, we will see through I'm sure the court's very familiar maybe with some of the injury cases, mesothelioma, all of those cases which have particular difficulties, but you will see within a tort context, and we'll go on to see this in the cases, the court is always more flexible to ensure that the test that's applied is the right one to meet the justice of the situation that arises. But this, and again, the defendants haven't given you a case where the global claims approach has been applied in a different context. It wasn't a line that the defendants took when we issued this claim. It was something which arose out of the comments I showed you by Mrs.
Well,
Justice.
one can't go so far as to say that a similar approach or this approach could never be applicable outside the context of a construction claim. But the question is whether it's appropriate here, isn't it?
Correct.
Particularly in circumstances where, on occasions, almost too many to number, Mr. Hermer was asserting that the claimant's case was not being brought on a global claims basis.
Yes, and indeed you
there's
see
just-
that's the pleaded case. Yeah.
At least twice in the last 5 years, and I don't want to start a hair running, but at least twice in the last 4 years, maybe, this court has said, re-emphasised that it is for a claimant to decide how they bring their claim. And I will have a look. Don't anybody waste time on it now. I'll have a look over lunch to see if there's any possible relevance.
In a way, the problem is not so much that the judge has, the problem from your point of view is not so much that the judge has labelled this a global claim, but that she has legislated in advance for the consequences of that characterisation by saying that if the defendants can show that there's any pollution for which they're not responsible, then the whole claim fails. Whereas the cases on global claim, whether John Doyle that we looked at yesterday or Walter Lilly, which we're looking at now, suggests that although you can plead the case in that way, if you have difficulties in doing anything better than that, at the end of the day, you look at the evidence and see what can be disentangled and what can't, and give your final judgment according to what the evidence shows.
Yes. I mean, I think our case does go a little bit further than that, because we wouldn't want it to be said that then we have to prove it in the way that's suggested under the global claims doctrine, because as we'll come on to see, there's a much more flexible test in tort, which is caused or materially contributed by. And that is important, because in a contractual context, the rules can potentially be different.
Well, should we be getting into that?
Yes.
Where sorry, I'm not inviting you, I'm asking whether we really need to, where the position will be governed by Nigerian law. English law seems to be developing. Professor Stapleton may be at the cutting edge, but we don't know and won't know till after the preliminary issues trial what Nigerian law has to say about this. Isn't it all a matter for trial? I mean, isn't the position simply that if you've pleaded a sufficient case on causation, then it goes to trial to be determined in accordance with whatever Nigerian principles of causation may apply?
Well, I think it goes a little bit further than that, because the defendant's position has been at the case management stage. That's a procedural question that is governed by English law. So it may be that the court at least would want to consider or make clear that in tort a different case applies under English law, that you're not prejudging anything in terms of the position under Nigerian law. But we say it is important to have a clear statement in terms of the place that the approach that's been taken, which pervades everything, which pervades the amendment appeal, this notion of leak loss, the linkage between the specific events in that sense, because I will show you in a minute why that is the case. Obviously, it's a matter for the court, how far the court wishes to go. But I would suggest it would serve a useful purpose for this court to clarify that, whilst making clear that, obviously, in this case, Nigerian law will govern it, and there is to be a preliminary issue on Nigerian law.
Surely what matters, and really almost the limit of what we can do, is to say that the claimants want to bring these thousands of claims, albeit aggregated, as thousands of individual claims, to which normal tortious principles of causation, be it under English law or Nigerian law, apply. And we should not go further than that, because the phrase material contribution is tricky in English law, and we have no knowledge of Nigerian law. But that's the way you want, the point is, that's the way you want to bring your case.
Yes, whatever happens, we need to get rid of this mantra of global claims.
Yes, well, we understand that.
And we need some clear guidance for the principles on which the case is to be case managed.
Yeah.
Because, as I say, it has an unfortunate effect. It's bled into everything that's happening in this case. And therefore, there are a number of ways of dealing with that. There's having a completely fresh start. There's this court giving some directions, a combination of the two. And I appreciate these are unusual circumstances. But this situation which has arisen is obviously extremely unusual.
I mean, what you want is to be allowed to bring a case where you can argue that all you need to prove is material contribution. Now, that argument may fail at trial, or if Nigerian preliminary issues are decided against you.
Yes.
And if it fails, well, it fails.
Yes.
You lose.
Yeah.
But that's the argument you want to have.
That's absolutely correct.
I mean, that's, in a way, that says in a nutshell, doesn't it?
It
all
does.
that this appeal is about.
Yes, correct.
Can I add one gloss to my lord's all in a nutshell?
Yeah.
Which is you definitely want us to say loud and clear that the mere fact that Mr. X loses does not prejudice the position of others.
Yes, we do, but also that I would ask you to go a bit further, which is that the test is causal materially contributed by the pollution. So when you're looking at the individual claimant, that where we've got to in terms of, as I say, this global claims notion infecting everything that happens must stop.
Well, I understand that, but I think whether material contribution is sufficient is perhaps not a question for this week. Your appeal formally is from the two declarations at tab 14, page 241.
Yes.
One, that the claims are to be progressed on the basis that they're global, i.e. all or nothing claims. You say that's wrong. And two, that the claimant's pleaded case precludes case management being organised by reference to the selection of lead claimants.
Yes.
So you say, although one can talk about the details of the selection process, that's the only way that a 2000 claimant case can sensibly be progressed.
Yes.
The question of whether it's sufficient to show that Shell's activities materially contributed to a particular claimant or lead claimant's loss doesn't seem to me to be something necessarily to be decided now, even if one didn't have the question, is it any different under Nigerian law from English law?
Well, I think the only thing I would say to that is there needs to be a basis on which the cases are being case managed, which is a procedural issue. So I think there does need to be a statement of those principles. Now, those don't need to decide it, but I think that needs to somehow come across in the judgment. And I appreciate this is a very, very sort of uncharted territory in some ways, but because of what's happened. And I would also say this, you've seen the history, the grounds were put in on that basis. We then had that subsequent hearing that led to the subsequent note saying, please deal with this as soon as possible. It is something which I think those dealing with it didn't really realise the extent to which it has infected everything about these proceedings. And certainly we are very, very anxious that this is now looked at. There's a completely fresh start and that we start again.
Now we embarked on this discussion about where the case is going at a point where you had taken us to Mr. Justice Waxman's judgment in Bille.
Yes, and it's also a useful place to look at Water Lily.
Yes.
So thank you.
So do we need anything more from Barthélemy, was it just 126 and 127?
Yes, that's it. The other case that's been referred to is William Clark Partnership, which is in Authorities Bundle 7. Tab.
Yes,
69, I think. I just think I've got the wrong one.
it is.
Yes. Again, this was a professional negligence claim concerning a construction contract. And in this case, the claimant professional services firm claimed £174,500 for professional fees arising from the construction of a new build primary healthcare centre in Lancashire. The defendant employer counterclaimed on the ground of alleged professional negligence in permitting a substantial overspend, about £730,000 above the contract sum, on the project. And so the issue for the court in this case was whether the doctrine of abatement could apply to the fees claimed by the firm on the basis of the alleged deficiencies of performance. And if we can turn to paragraph 149. Okay, sorry, I think we've got a different version. Bear with me, we'll just find the passage. So if we look at 6.20, which is page 2828, and there the court found that the claim is presented by Dock Street, albeit a claim for damages for professional negligence, has the essential characteristics of a global claim. And then you will see the reference again to Aikenhead in Water Lily. But again, you will see that those same factors were identified. Numerous breaches by Clark, which are said to be potential actual causes of cost overrun, a total cost payable under the building contract, substantially exceeding the original contract, a claim for the difference between the two, where the overruns attributed to Clark's breach without any detailed particularisation of the causal connection. So again, doesn't assist, and then there's pages that follow discussing what Water Lily finds. I don't think we need to go through that, but you see the facts there are not this case. Obviously, if there are any other cases raised, I will deal with those in reply. We have not found and have not been taken to any cases analogous to this case where global claims has been applied in the way it's sought to be used here. So, taking note of the court's concern about how far it can go, can I ask the court to bear with me while I go through three things in relation to the test in tort, which I appreciate is a topic, material contribution, has taxed the courts for a long time in the context of tort claims. But I want to take you to Rahman and Arrows, then to Arch, and then to Professor Stapleton's article that's written after what the Supreme Court says about her previous articles. So first,
She takes the view that the Supreme Court in Arch validated the arguments that she's been making for many years.
she does.
More or less.
But we will see in my submission that they do. That's precisely, they say very, very clearly, but for, as a test of causation, has limitations. And indeed, we will see in Arch that they refer to pollution where there's multiple causative effects. So she in effect puts forward, she takes that and their endorsement of her two previous articles and says, this is the Supreme Court now saying, and it's pretty clear that's what the Supreme Court do say.
All right, we're going to come to that.
Yes.
We said we need to look at
Sorry, yes.
Rahman before.
I just wanted to look
Arch.
at this. This is an old case, but it shows that actually it's not a new approach that Professor Stapleton is taking. It's something that has been around for a while. Rahman and Arrows is at Authorities Bundle 5, 48. And this is your Justice Laws in the Court of Appeal. It's a case concerned with the rationale and scope of the rule that concurrent tortfeasors are liable to compensate a claimant for the full extent of damage caused by concurrent wrongs. And if we can look, please, at paragraph 17 of the judgment, 1951. Lines 3, 4 and 5, tortfeasors are concurrent where their wrongful acts or omissions cause a single indivisible injury. In such a case, each tortfeasor is liable in full to compensate the claimant for the whole of the damage. And then we have some other learned authors quoted, Professor Glanville Williams and Prosser on torts. And then if you turn over to page 18, 1952, the reason for the rule that each concurrent tortfeasor is liable to compensate for the whole of the damage is not hard to find. In any such case, the claimant cannot prove that either tortfeasor singly caused the damage or caused any particular part or portion of the damage. Accordingly, his claim is to be dismissed. But that would be the plainest injustice, hence the rule. So what we see in these tort cases is different, in my submission, to contracts, because the rules are ameliorated to ensure that justice is achieved. So that's Rahman and Arrows, just to show that that has quite a long pedigree.
One has to acknowledge that that is a statement which applies to what one would, in injury cases, describe as an indivisible injury.
Yes.
Doesn't apply if you've got an incremental injury where you can identify or should be able to identify the additional. And that is a question which it is easy to imagine could arise on the facts of these cases.
Yes, although it may be that if you have two polluting events where the oil is mixed together, it may be difficult to disentangle
Quite
it.
acceptable.
So then can we just have a look at what's said in Arch, which is at Authorities Bundle 3, tab 19. It's a very long case, obviously, about insurance, but we only need to look, you'll be pleased to hear, at a page and a half of it. It's page 909 of the bundle, paragraphs 182 through to 185. And again, I'm not going to read through all of this. Maybe I could just ask you to read 182 to 185 to yourself,
Yes.
please.
The one moderately controversial sentence in that passage is the sentence, another example is where multiple polluters discharge hazardous waste into a river. Because it could be said, and has been said, that that needs to be qualified to make clear that it is of the same type as the previous examples. Because as you've said, different questions may arise if on cases of admixture and the nature of the damage and so on and so forth. Would you accept that? They are not saying, well, I do not read them as saying, that if you can demonstrate that more than one tortfeasor has discharged poisonous waste, hazardous waste into a river, they are automatically, without more, liable for the whole.
Yes, I would accept that, and you will see that we have said, we've always accepted that we have to prove a causal link. We don't shy away from that. We've said that's what we will show. The question is, causation of what? And that's the problem that we see in the amendment appeal, that it's a fixation with one leak, but for that leak leading to the loss. That's not the law. So yes, we have to prove causation, but for is the starting point, but it's not the end point. And that's really what Professor Stapleton goes on to say. And we say she's absolutely right. The opening of this is the Supreme Court making clear that the but-for test in and of itself is inadequate. Not only because it can include too many things, because it can exclude some cases where one event could be regarded as a cause of another. So it's the last sentence in a way that we rely on. It says in all these cases, each individual contribution is reasonably capable of being regarded as a cause of the harm that occurs, even though it was neither necessary nor sufficient to cause the harm by itself. It still has to make a material contribution, otherwise there's no causation. So we don't shy away from having to show a causal link, but the link that it's been suggested we have to show under these principles is wrong with respect. And that is what we are keen that the court makes clear is for the purposes of case management. That's English law. Obviously under Nigerian law, we have a whole panoply of things that will need to be looked at, some of which could be stricter than this, as we've seen, because you have statute, you have constitutional law, you have all of these things. So, of course, the substantive law will have to be determined in due course. But the way in which it's being approached, and indeed even the way the amendments are presented, is not right, because this is what we have to prove.
Although this is helpful to you as far as it goes, no doubt, it's not, as you accept, a statement of Nigerian law. It is on any view obiter, since this was a case about causation in contract to do with the particular insured peril under a business interruption clause, and the circumstances in which multiple polluters discharge hazardous waste into a river may vary widely. So it's building quite a lot on this example to say, well, this is good enough for us. If we can show material contribution, we win. That may or may not be so, but it's premature to say something about that at this stage, surely, until we know a bit more about what the facts are and what Nigerian law is.
Yes, I mean, I accept that. I think the difficulty in this case is that we've been presented effectively, the defendants haven't actually pleaded any other test that's applicable apart from global claims. So their position is, the global claims position is correct. This obviously shows this is an additional reason why that's not the case. But I understand the point. Well,
their case is that it was all or mainly the fault of illegal refiners, for which they say they're not liable.
Yes.
They either are or aren't liable for illegal refiners. And if they're not, then that's what their case is.
Yes, but their case might still not succeed even if they show that. And obviously we say they will be liable for those. But say you had a situation where a claimant was damaged partly by a leak that Shell were responsible for, and partly by, say, an illegal activity which Shell were not responsible for in this scenario. We would say, if we can still show that Shell's leak made a material contribution to the damage, they're still liable.
Well, I know that's what you say, and that's why I said earlier, what you want is to be allowed to run that argument. But I don't see that you're necessarily entitled to have us tell you that if you run that argument, you'll win.
No, and that's not what I'm seeking. But we must get rid of global claims as a concept, including in relation to the test of causation and what we have to show, including in relation to case management. And certainly it would be helpful if the court can articulate our argument on that issue, because actually at present on the causation issue, it's either global claims, as the defendant says, or it is this test. Then can I just take you to Professor Stapleton's subsequent article?
Sorry, just
Yeah.
So I'll say this while I remember it. Looking at the multiple polluters example.
Yes.
Lords Hamlin and Leggett say that in all these cases, i.e. including multiple polluters, the harm is reasonably capable of being regarded as a cause, even though it was neither necessary nor sufficient. Well, the individual pollution, the multiple polluters example, it may be that facts would show that one individual's pollution discharge was sufficient, which would at least bring a difference from the example that the Supreme Court are dealing with, which is why I say that the circumstances of multiple polluters may vary quite widely.
Yes. No, absolutely. On the facts, there may be different findings.
Yeah. Okay, thank you. Sorry.
Yeah. So if we can just have a look at then Professor Stapleton's article, it's in volume 8. should be tab 88, the last tab. And you will have seen from the Supreme Court passage, they referred to two previous articles of hers, which aren't in the bundle, because we don't think you need to trouble yourselves with that. But obviously you will see that she then wrote this article in September 2023. And if we, again, I would ask you in due course to read this to yourself. I'm just going to draw your attention to a couple of passages. If we look on page 3425, we see that she sets out halfway down the page the fact it's long been acknowledged the but-for test of necessity is inadequate, where multiple factors are each sufficient. And then she obviously sets out, and I appreciate this is her view, but she does say that is a very important precedent, combined with, I might say, the court's general approach to environmental claims. The authorities coming out of the Supreme Court are very much speaking to one voice on this topic at present. And then at 3426 over the page, just before section 2, she sets out why FCA and Arch, even though it isn't a tort case, it's about insurance contracts, as we know, that it's actually important still in relation to tort. She then goes through, if we turn forward to page 3431, penultimate paragraph from the bottom, to talk about the hypothetical used by the court in Arch that we've been discussing. Multiple parties discharged hazardous waste, and she then refers to a US case, Northup and Eakes. Several polluters independently and culpably discharged crude oil into a river. The oil ignited, destroying the plaintiff's barn. Oklahoma said each liable and negligent for destruction, even though it can be shown any individual discharge was necessary or sufficient. And then she talks about Germany and does a comparative discussion, which I don't think we need to take time over. And then at 3434, we see her conclusion is that we now have two tests. So again, just above the heading in bold at the bottom, 4.2, you will see two types of causal connection can be captured by a simple exception of the traditional but-for test. The outcome would have been absent, or a contribution to the mechanism by which it came about would have been absent. And so you will see that she calls that the extended but-for test, and she says that's also supported by the other cases she cites. So I simply refer to that to show you how that has been interpreted as being wider than, it's not confined to insurance cases. We say it is a clear statement. And certainly we should, beyond any doubt, be permitted to run this case on the basis of causal material contribution. As you pointed out quite correctly, obviously we don't yet know what the position will be under Nigerian law. We referred to some of the Nigerian law examples in our skeleton simply as examples of further ways in which the global claims analysis is incompatible with those claims under Nigerian law. Again, I don't think that we need to spend very long on this, but the ones that I would particularly draw to your attention are at paragraph 52 of our skeleton, which is Core Bundle 1, tab 12, page 180.
Are we leaving Professor Stapleton?
We are now, yes. I want to just take you very briefly to the Nigerian Supreme Court case in Centre for Oil Pollution Watch and NNPC. That's in Authorities Bundle 8 again. Sorry, I know you just put that away. Tab 75.
Could you just give me the number again?
Yes, it's Authorities Bundle 8, tab 75. It starts at page 3094, and I would just direct your attention to page 3119. This is a case primarily about standing, but you will see that the court also took the opportunity to reiterate that under the Constitution, if you look at 34, courts in Nigeria, by virtue of those provisions of the Constitution, all of which we pleaded in this case, Section 17.4 of the Oil Pipelines Act and the Oil and Gas Pipeline Regulations, under a duty to protect the environment and would fail in that duty if they do not facilitate the protection the laws have put in place. And then again at the bottom, duties of the oil pipeline licence holder, setting out that these regulations require and the Constitution require oil pipeline licence holders to, and this is the last 4 lines, institute mechanisms for prevention of accidents like crude oil spill and remedial action for protection of the environment. And then the only other passage I'd take you to within this is at 3168. Again, the penultimate paragraph, just over halfway down, the court refers to the Learned Respondents Council.
Sorry, what page are you on?
Sorry, 3168 of the
Thank
bundle. That's the place in the judgment where the court sets out the duty to protect the environment would fail in that duty if in the instant case they do not facilitate the protection these laws have in place. So that is something that will be applied by courts in Nigeria. Again, this isn't for you, obviously. It's simply a further reason why the global claims approach is fundamentally inconsistent with that, particularly when it's been applied by the judge in the wrong way, which it has been here. And that's confirmed by the Fundamental Rights Enforcement Procedure Rules. That's in our skeleton argument, Core Bundle 1, tab 12, page 181. It's also in the pleading at Core Bundle 1, tab 26, 413, paragraph 39. That says the Constitution, as well as the African Charter, shall be expansively and purposefully applied with a view to advancing and realising the rights and freedoms contained in them and affording the protections intended by them.
I'm very sorry, I'm being very slow. If you're on page 181, are you at the end of the first paragraph?
Yes.
Thank you.
Sorry, yes. And I'm a bit behind, but that will be in the bundle that you've been given.
It's all right. We'll take it from
Yes,
for the
we'll
moment.
take it from there. And then we obviously also refer to the fact of Bodo, which was considered by Mr. Justice Aikenhead in 2014. Again, with reference to there may be a place for the res ipsa locta doctrine being applied. Again, we don't need to go into that, but I simply set out that all of these principles are fundamentally incompatible with the global claims approach. And then we've also seen during the course of argument on the amendment application the fact of strict liability under 11.5c, which we discussed about this morning, yesterday, you may remember, there's an inverted burden and standard of proof. Again, all of that fundamentally incompatible with global claims analysis. And then we have the eager spin guidelines. A spiller shall be liable for the damage from a spill for which he is responsible. Where more than one spiller is responsible and liable, the liability shall be joint and several. We've also set out in our skeleton, I'm not going to go through it, that the concept of global claims in this context is incompatible with the right to a remedy. That's in our skeleton at paragraph 53. That's Core Bundle 1, tab 12, page 182. I'm not proposing to take you through those cases unless you'd like me to. In particular, though, the extract from X minors in Bedfordshire, we would just emphasise the rule of public policy, which has first claim on the loyalty of the law that wrongs should be remedied. And obviously, we've shown you why that won't be the case on the current approach being taken. And we have also made reference to the Privy Council decision in, this is paragraph 53 in the footnote, to the Petroleum Company of Trinidad and Tobago versus Ryan, 2017 Privy Council case. Again, where the court said that even though the but-for test of causation wasn't strictly satisfied, there was sufficient evidence to find in favour of the claimants. I'm not going to go to that, it's all fact specific, but these are all further reasons why global claims is not the right approach. Global claims, in the way in which it's been applied, is even less the right approach. But we say it's time that we cleanse these proceedings of global claims terminology, global claims principles, and we start again. I wanted then, in the time that I have left, to deal with the issue about disclosure and what we have and why it's not sufficient, to look at what we say. The purpose of Mr. Leader 4's, his statement was to set that out for you. And then I think I have already dealt with why we say this is suitable for a lead claims trial, but obviously if there's anything else on that. So can we then put the authorities away, and can we please just look at Mr. Renshaw, his 7th statement? That should be in Supplemental Bundle 2, tab 28, and if we can start at page 588. And again, I'm just going to, I'm not even going to ask you to read this to yourselves now, but at some point I would point and draw your attention to the depth in which this was dealt with before the judge in terms of the difficulties that there were with identification of spills. And then if we go forward, he deals with that 97 onwards. So you have unpublished spills 98 to 104. Then at page 592, he then deals and explains undetected spills and sets out the evidence in support of that. And then if we go forward, that's paragraphs 105 to 110. Then page 595, paragraphs 111, we've touched on this already, all the way through to 597, 114. That's to do with the unreliability of the JIVs.
No, just because I have not read the whole of Renshaw 7.
Yeah.
You just asked us to read, not now, 97 to 114.
Yes, please.
Okay.
I actually asked you to read in total 98 to 142. The whole of this is incredibly important because it's constantly said that we've done this as a strategy, as a tactic to get some kind of advantage. There's no problem with us just pleading things out on the basis of what we have. We not only have put in a further statement from Mr. Leader specifically addressing where we are post such disclosures we've had, which is limited, but there was before the judge this very detailed evidence explaining what the issues were in terms of giving more particulars. And at 597, we set out, sorry, Mr. Renshaw sets out how the claimants will prove their case of causation at trial. So we weren't saying this was something we would never do. This was set out in detail. And it's clear from this evidence that the claimant's ability to particularise and plead the relevant spills that cause their loss and damage is contingent upon the provision of disclosure referred to and expert analysis of that evidence. And as I say, I don't believe that should be particularly controversial because we've seen the defendant's solicitor put in that statement saying the same thing, that the experts need to draw on a variety of documents in order to produce their analyses. And he deals with the disclosure relevant to the case on causation at 603, all the way through to page 606, so that's paragraphs 137 to 142. And then he then deals at 606. He goes through and deals with, in fact, this section is also relevant, how you select lead cases. I went through with you on the map yesterday. We actually say it's pretty obvious how you do that, but there was detailed evidence before the judge about how you do that. There's nothing from the defendants beyond saying, unless you can attribute each specific spill to the damage, we can't select lead claimants. So they refuse to engage with selecting on this basis. And we've seen the judge took that view too. It's recorded in her judgment.
And just going back to what you said yesterday, or told us yesterday, thinking of the map with the 94%.
Yes.
Your response to that submission from the defendants is we can't identify the spills, but we can identify where the damage is.
Correct.
And you need expert evidence in order to identify the source of that damage.
Yes. And indeed more...
So if you... I should just bear with me a second. So if you were to select lead cases by reference to the prevalence of damage, that would give you, on the information you've provided, a temporal and a geographical tether for disclosure, choosing lead cases, whatever you wanted.
Yes.
Is that more or less in line with what you propose?
Yes, it is.
Okay.
Yes. And in addition, we make the point that through the SOIs, you can also determine additional things that you might want to determine. So limitation, types of loss, because we've given all those details. So we're not just tethering it to damage. It's that those SOIs, which we spent a lot of time and money producing, can be analysed.
Yes, but it's surely inevitable that if the court, whether us or the High Court, were to go down the route of lead cases,
Yes.
then the individual cases would have to be worked up in greater detail from where they are now.
Absolutely, and that,
even though you can't, what you say is you're not prepared or able to try and work up 2,000 cases with a view to identifying lead cases.
Correct. Correct. We've set that out. Yes. If we look, we've set this out in our skeleton. If you could just look at that, I'll show you where it is located, because we were very keen to ensure that we clearly set out the pathway to resolution. Yes, which was the section that I was referring to earlier. So it's tab 12 of Core Bundle 1. It starts at page 190. So we have your judgment, we have a fresh start, we have the Nigerian law issues, but at the same time we also have, in tandem with preparation for that, that we have selection of lead cases, and then we set out that you have the normal thing, you have questionnaires, you would then have, and that's questionnaires from a pool. We proposed 100 potentials that we do questionnaires for, and then that each party would then choose 6 with the intention that 12 would collectively cover all of the 12 most popular fishing sites and a wide variety of pollution incidents. And that, as we say, would result in 94% of the Bille individual claimants who fished being examined and tested. And then you will see we have disclosure and pleading of individual particulars claimed for lead cases, following selection of lead claims and provision of standard disclosure, and then we have a trial of the lead claims. And then obviously you would get to the point of having those determined. And there is precedent for the court ordering this. So Vedanta, which we set out at 81, and again that's in Mr. Renshaw's 8th statement. He goes through this in detail, which you have the reference for. We don't necessarily need to go there, because it's set out in summary in the skeleton, but it's supplementary bundle to tab 30, page 632 to 636. There's 4 pages of detail there of how in Vedanta it worked. Nowhere in Vedanta was it alleged that you had to link losses to any particular polluting event, and that's the real problem with global claims approach and the way it's been applied perversely in this case, because it hasn't even been applied in the correct way. There's also the case of Bodo, and we don't accept, as the defendants say, that Bodo is irrelevant. It still shows these sorts of claims being managed in this way. So both of those are very, very useful precedents. In neither of them did you need to identify particular polluting events. And that's particularly true of Vedanta, because that was toxic pollution from a mine over a significant period of time, in fact far greater than is an issue in Bille, because there it was alleged that the harmful effluent and air emissions had occurred since 2004 and were ongoing to 2020. Now, in terms of what further information is required for the claimants to plead their case on causation for all those lead claims, we've also dealt with that at paragraphs 84 all the way through to 91. And then at 92, we set out the further information required, which I'll come to. But again, I'd ask the court to look at that, because we've explained in a lot of detail. Now, I'm going to come to the disclosure that we have already in a minute, and why we say that's insufficient. But then, if we look forward at I3, a question had been asked when permission was granted: what do the claimants accept or assert is the minimum requirement that they must satisfy in formulating their case, so the defendants may understand the case it has to meet, and the court may understand the parameters the case has to decide? And at page 198, paragraph 94, we have set out in terms what we would put in the individual particulars of claim once we have standard disclosure. So again, I would ask you to read that. If we are able to specifically identify precise locations, dates, then we'd set that out in these individual particulars of claim for the lead claimants. If we could identify some but not all the spills, then we would plead those that we could, and then plead a defined range of probable locations and dates, and all specific facts that we rely on as a basis, as an inference for the court, to conclude that we suffered damage. And then finally 3, if we couldn't plead that, then we would need to plead the specific facts described that I've just been through. So this is a claim that we want to plead out and prove at trial, and we believe we can. It's simply that we need standard disclosure to do that. If I can look then at why what we've had to date is insufficient. Mr. Leader 4, if we could look at that, it's in the unagreed bundle. And just tab 3 of that. If we can go to page 10 of the bundle. You will see he sets out there the purpose of the witness statement, which was to respond to another question which had been raised when permission was granted. What further information and documents we required to plead these individual cases on causation. And it is obvious, it is said that we haven't said that we are unable to plead. We have repeatedly said that. It's in the reply, paragraph 13. It's in numerous witness statements that I've taken you to, and this carries on. We only need documents in order to plead it, because without them we're unable to plead. But you will see the defendant's skeleton persists in saying that we can do this, despite what we say. Then paragraph 5, it's also said by the defendants that we haven't consulted with experts. And we haven't put any expert evidence before you or before the judge. Again, we don't accept that. Both Mr. Renshaw and Mr. Leader have set out in terms. Members of my firm have held privileged discussions with experts in various disciplines, including hydrology, pipeline integrity and engineering, oil spill response, cleanup and remediation, satellite imagery, mangrove ecology, oil chemistry and lab analysis. I do not waive privilege in relation to those discussions, obviously he can't, but confirm that the list of further information documents in this witness statement has been informed by them. The documents identified in this witness statement are also documents which the experts have stated they would expect to be in possession, custody or control of the defendants as a matter of standard industry practice. And then he sets out why he's focusing on Bille, paragraph 8. He says, please read this in conjunction with paragraph 77 to 154.
Forgive me for it's a thing that I've thought about 4 times and managed to resist asking. So, is there any material? We've done everything by reference to Bille.
Yes.
And apart from the fact you've referred to different particulars of claim.
Yes. Yes.
I don't detect any difference of principle in any of the submissions that have been made in relation to Bille, but is there anything that we need to be aware of in making statements about Bille where one might need to make an exception for something in Agale?
Yeah. Yes. Yeah. So if you look in Mr. Renshaw's 7, he deals in detail separately with Agale and Bille. Generally no, but we have slightly different types of environment. So hydrologist is obviously relevant to Bille, but you might be looking at hydrogeology when it comes to Agale. So different types of experts. But in terms of the general principles that we've been discussing, no. And then he deals at 9 with the map that I showed you yesterday. And then he sets out the categories of information that are still needed in order to identify, or to try and identify, because of course this may or may not be possible, the spills. So category 1 is obviously documents and information relating to asset integrity. If you turn over to page 7, we see a list of those at 15. So far, I think we have been given 3 annual pipeline asset integrity reports. But certainly we don't have these categories, and these are categories that the defendants experts need, and indeed to a degree the defendants accept. There's a wide variety. Sorry, the claimants experts need. And the reason for needing these is again at Renshaw 105 to. Sorry. Give me 1 second. I've just lost my page. Sorry, I'll come back to that. I'll come back to that. Okay, yeah, sorry. If we can go to, if we can have Renshaw 7 out as well. So that's supplemental bundle 2. Page 593. And there he sets out the issues that there have been with pipelines and infrastructure having no leak detection systems. They've not used intelligent pinging devices, can only touch oxygen, etc. And without those, then there's no reliable way to detect oil spills or ongoing leaks. We would like this information, to the extent it exists, to be disclosed. And that is information that our pipeline experts need in order to try and ascertain what happened. And then if we...
Sorry, I don't understand that. They say they don't have any leak detection systems.
Yeah.
So why are you asking for what they say they don't have? Or have I misunderstood?
Sorry, there are leak detection systems. We just say they're not sufficient. Sorry, forgive me.
Well, Mr. Renshaw says that the defences admit no leak detection systems.
Right. Yes. Yeah. Sorry, that's my fault. So the point is, there aren't leak detection systems. Therefore, we need these documents in order to ascertain what leaks occurred.
And that's paragraph 14 of
That's paragraph 14 of Mr. Leader. Then we have category 2, which is documents and information relating to the amount of oil discharged into the environment. And these are primarily documents that the independent experts in hydrology need to be able to construct a model, simulate the movement of the oil spills. And in fact, what we can see is there's a measure of agreement here between us and the defendant, which I will come on to, but you will see that they've also suggested that a model could be built. And that's the one that needs input from a wide variety of documents. And then we see those documents specified at the top of page 16, daily production reports, leak detection information, emergency shutdown procedures, etc. We don't have any of those. Then category 3 are documents and information relating to oil spill response, cleanup and remediation. And we can see that those will help establish the volume of oil that remains in situ, what impact that will continue to have.
What page are you on?
Sorry, I'm looking at paragraph 19, my lord. And then we have the list at page 17. In total, from what's been disclosed, we believe we have about 650 documents in this category, that's it. And many of those also JIVs, which we don't accept are helpful for the reasons that we've set out. Then in relation to category 4,
I'm sorry, just going back to my previous question. You
Yes.
say it's a complaint that you make. They had no leak detection systems in place. They admit it. And then here you are asking at page 16, little b at the top, for their leak detection system information. I mean, you're asking for documents which on the pleading, it's common ground, don't exist.
yes, that's a fair point. And I'm being told that that in that sense, the leak, if they don't exist, if there is not a single leak detection information, so that would be B on page 16. That's absolutely correct. If that doesn't exist, but what we do need is pressure monitoring data, and that we know does exist. So that's the corollary of that, if you don't have the leak detection system, you need the pressure monitoring. But I agree. But the point of this, my lord, was to illustrate the types of documents that we need, because we say the way to deal with this would be through an order for standard disclosure anyway, because as we've already discussed, there'll be a lot of fault-based documents which will also be relevant.
But I think you're only giving us an idea. You're not asking us to
Correct. That's correct.
act
That's
as
correct.
though we were
No, we're not.
a master
No, we're not.
on a summons for further information.
Yes, okay. And another point that's made is that we're not just asking for documents. So the question that came on the permission to appeal was further information or what would we need by way of further information or documentation. So we still don't know exactly what they do have in place. And as you've said, my lord, we're not asking for some kind of order on this. It was simply to try and illustrate to the court the types of things that we needed. And I'm going to come back and just look at paragraph 104 of the defendant's statement, which is the defendant's skeleton argument, which says you can plead all this. And this is to illustrate that we can't. And then we have at category 4, paragraph 21, any of the following categories of information and documents relating to hydrological oil migration. And these are all needed for the model, again, that would be built. And you will have seen that one of the things that we've suggested is that independent experts from each side should discuss and agree and try and progress that model as soon as possible. And we hope, from what's been said by Mr. Boyne, that there may be able to be some areas of agreement about that. Now, can I then just come back to deal with what the defendants say, because in a sense this is important to show you that when they say we can just plead all of the relevant spills now, they are wrong. So this is paragraph 104 of their skeleton, where they make a number of arguments as to why we can plead now. So 104A they say two things.
Just a moment. Page 229.
Yes.
104A.
Yes.
Thank you.
104A, they say there's always been a large volume of detailed satellite imagery. And secondly, we've disclosed the full JIV reports for all pleaded spills. And then they go on to say that we've repeatedly told the court that analysis of imagery will be critical to identifying the spills, so you should just get on with it, with the images, the satellite imagery, and those limited JIV reports you have. Well, with respect, it's simply not possible to identify the spills and link those on the basis of satellite imagery and JIV reports alone. We've been through now a number of times as to why the JIV process is severely unreliable. They're not going to provide a reliable baseline regarding the number, dates, location and sizes of particular spills. And obviously this is very important. Mr. Justice Aikenhead often uses the phrase garbage in, garbage out. But it's very, very important to have proper data to put into any model. And the information contained in the JIV reports is, with respect, a paradigm example of unreliable data, which would simply lead to severely unreliable outputs. And indeed, we saw that in the defendant solicitor's statement when he said the experts need a wide variety of data. Secondly, the JIV process is by definition one which only concerns oil spills which Shell has detected. And that's again set out at length in Renshaw 7 and Leader 4, that the damage, our case is that the damage in Bille and Alame was caused not only by leaks which were detected, but also by numerous other spills which were not detected. And again, for your reference, that's Mr. Renshaw at paragraphs 105 to 108 of his statement. He explains those pipelines are and were in a chronically poor state of repair. And so all of these undetected spills will by definition not have been the subject of a JIV investigation and report. Satellite imagery. It's difficult to use satellite imagery to be able to identify oil, particularly for onshore spills. Whether that's possible will depend on many factors. Was a satellite image taken the day after a spill or the next image taken 3 months after? How large was the spill? Was the spill on land or water? What's the resolution quality of the image? So while you can use satellite imagery to detect large offshore spills, it can be challenging. Further, satellite imagery simply provides a visual snapshot of an area at a certain point in time. And what you use satellite imagery for primarily is to detect damage to mangroves. Now, you will have seen in the pleadings, mangrove damage is one, but not the sole types of damage we complain about. But also, mangrove damage isn't instant. So if you have an oil spill, say on Monday, you might not see much mangrove damage on Tuesday, so you'd have to have a whole series of data in order to try and draw conclusions. Also, the rate of mangrove death will depend on other factors: volume of oil, characteristics of the mangroves, topography, chemical composition of oil. So that all needs to be dealt with by people far more qualified than me, but satellite imagery alone doesn't allow you to determine where the leaks were. The next problem is that even on the evidence we've been given, it appears to be incomplete. It would be very difficult to use that to draw any conclusions. To date, we've only had 38 satellite images for the 6-year period from 2009 to 2014. We've only got 6 satellite images for the whole of 2013.
38 for when? 2011?
That's 2009 to 2014. And just 6 the whole of 2013. Now, it's common ground that you need to, in order to try and link particular spills to damage, you need to understand how oil migrates in the environment. And that obviously will depend on hydrology by an expert in Bille, because that's obviously an aquatic environment. And as I say, at paragraphs 110 to 111 of their skeleton, the defendants refer to the possibility of creating this pollution model. And they recognise that to create that model will require data and expert analysis across a range of disciplines. And we agree with that. Obviously, precisely how you build that model, I think they talk about their experts saying you work backwards. Our experts actually say you work the other way, but again, that's something for the experts to discuss. But it's only through that kind of process that we're going to get anything reliable. So JIV reports satellite imagery nowhere near sufficient to enable reliable oil migration modelling to be carried out. And then at 104B of their skeleton, the defendants then say that because we had that specific disclosure that we've looked at, then that's fine. We've got all the information we need. They say very broad disclosure was ordered, including, and I'm quoting now from their skeleton, a vast amount of imagery as well as contemporaneous records which identify both spills and Shell's analysis of that impact, spill impact maps. We simply don't accept that. We haven't had vast swathes of documents. We don't have anything approaching a meaningful proportion of the disclosure that would be expected in a case such as this. To date, 65,310 documents have been disclosed. Of that 65,000 odd, 58,672 are image files. Only 6,638 are non-image. More than half of the documents are overflight images. So we've got 39,000 overflight images, and of those, 6,000 are duplicate images. So 10% of this disclosure that we've had is simply duplicates. So we would ask the court to reject the suggestion that we're now in the position of informational asymmetry. Containment reports and spill impact maps. We only have a very small number of documents. We have 21 containment reports, loss of containment reports, and 95 spill impact maps. That is obviously insufficient. Then at paragraph 104D, the defendants say data concerning pipeline pressure and flow is, quotes, unlikely to be of any use for the purpose of analysing spills and causation.
Where are you?
That's paragraph 104D of the skeleton, which is on page 230 of the bundle. In my submission, the relevance of pipeline pressure and flow rate data is self-evident. Because the defendant's reporting of spills is unreliable, we need these to calculate the amount of oil which has actually been discharged from the pipeline, at what time and in what places. And a key way that we will be able to do this is by reference to data regarding the pressure and flow rate through the pipeline, obviously in conjunction with other data. Changes in that data will indicate loss or leakage. Now, of course, we're not saying in and of itself we identify all spills from this. It's to be in conjunction with other data. And indeed, even Mrs. Justice May, again, we don't need to go back to it, I don't think, but in her March 2024 judgment at paragraph 32, she refers to the fact that pressure data has noted a reduction at a particular point. And she talks about how that might potentially be relevant and disclosable even within the 3Cs trial, but she hasn't ordered it. And we don't have it. There's no dispute about that. In Boyne 14, paragraph 28, again, he says that this data is not useful and reliable. He says you can't use pipeline data to identify unknown or undetected leaks from Shell's pipelines. We ask you to reject that not least because it's actually contradicted by the defendant's defence.
David? I think the short highlight has got a point.
I'm afraid the transcript has stopped completely.
Sorry?
The transcript has stopped completely, like a few minutes ago.
Oh, right. The transcript has stopped completely.
Dear, I bored it into stopping.
Yes. Oh. I don't know whether it's because of anything you're saying or not saying. I was going to question anyway whether you are turning this into a sort of summons for directions before
Of
us,
course,
where what we're concerned about is an appeal from the two declarations. Well, one thing we could do if the transcript is given up is to break off now, but the other thing is that we could rise for 5 minutes and see what the problem is. How much further have you got to go, Ms. Day?
I mean,
You were
almost
scheduled to finish by the
yes, by
lunch break
lunchtime.
today.
Yes, I'm very nearly. I'm pretty much there. Obviously, we have a lot of detail in response to these. My understanding is that you will be told by the defendants that we can prove our case. So I was keen to address those in detail. If the court feels it has a flavour of what we say in response, I'd be happy to stop at that point and break early for lunch and let Lord Goldsmith address you this afternoon, because I believe that I've addressed most, but I'm happy just to check that with those who sit behind me, to check whether there's anything else particularly important that we need to mention, and
Well,
perhaps shorten it a little this afternoon.
Should we break off now, come back at 1:45?
Yes,
If you feel you need another 5 or 10 minutes, then
that's fine. Yes, that sounds
have
perfect.
it. Otherwise, pass the baton to Lord Goldsmith.
What rise available?